Hello friends, today's topic is third party information under the RTI Act. So third party is a difficult concept under the RTI Act which is defined under two sections, that is section 2 and section 11. I request the new viewers to please subscribe to the channel and like the videos. Third party information under RTI Act 2005 as per section 11 contains the process, and under section 2n the definition is there. Third party means a person other than the citizen making a request for information and includes a public authority. So it means third party is not that person who is asking for information, and third party is the person to whom the information pertains to. Okay, so this could be an individual, a company, a society or association, another public authority. Now we will have an example where you will easily understand what is third party. Citizens and public authority. The RTI Act grants the right to information to all Indian citizens. When a citizen submits an RTI application to a public authority, that public authority becomes the first party involved in the process. Third party definition. If the information requested by the citizen pertains to or was provided by someone other than the citizen or the public authority processing the request, that someone is considered a third party. So here we could easily get, so the third party is someone else for to whom in respect to whom the information has been asked. So when does section 11 apply? Section 11 is triggered when the information requested relates to or has been supplied by a third party and the information has been treated as confidential by that third party. So there are two parts, that the information should be relating to or supplied by third party and that has been treated as a confidential information. Examples: salary details of a colleague, copies of contracts signed with private vendors, documents involving another individual or organization. So here we move ahead. Procedure to handle third party information. So we have a detailed procedure how to handle if RTI application relates to third party. So we have to first give a notice to third party. I tell you an example, that an advocate is asking information in respect to Mr. X from the public authority. Now Mr. X is an employee of that organization where public authority is also working. So for taking information in respect to Mr. X and providing it to the advocate, we have to first seek permission from Mr. X. So here first step is notice to the third party. So Mr. X here is the third party. The public information officer must give written notice to the third party within 5 days of receiving the RTI application. Opportunity to object. The third party is allowed 10 days to make a representation in writing stating whether the information should be disclosed or not. So here in the third party has 10 days to reply to the notice whether information in respect to that third party can be disclosed or not. Whereas public authority has 5 days to write to the third party. And then the decision. The PIO must consider the objections raised by a third party, whether larger public interest justifies the disclosure. Then right to appeal. If the PIO decides to disclose the information against the third party's objection, the third party can appeal against the decision. So it generally not happens if the third party, which is Mr. X, for which we have taken the example, Mr. X has not agreed, then generally the PIO never provides information. So here the case is taken if PIO has provided the information, Mr. X is within his full rights to raise an appeal. Important legal points. Not all third party information is protected. If the information involves public activity or use of public funds, disclosure may be justified. The PIO must apply Section 81J Personal Information, 81D Commercial Confidence, and Section 11 together to balance privacy with public interest. So, it is clear from this para, if information relates to third party, then Section 81J, 81D and Section 11 can be applied for not disclosing the information. Example for disclosable and not disclosable information. Names of beneficiary of a government scheme can be disclosed. Details of contract in public project can be disclosed. Qualifications of government employees can be disclosed. Medical records of a third party cannot be disclosed. Income tax returns of another person, unless public interest involved, cannot be disclosed. Personal service records without consent cannot be disclosed. So we have an important case law here, that is Arvind Kejriwal versus CIC 2010. Delhi High Court held that public interest must override personal privacy for disclosure of third party information. PIO must weigh both aspects carefully. Summary. Third party, any person or entity other than the applicant. Section 11 of RTI Act. Notice period 5 days to inform third party. Objection period 10 days to reply for the third party. Key condition, whether information is confidential and if public interest overrides it. So this is the whole topic. I hope you have understood it and the matter is clear to you. Thank you very much. Thank you for listening.